required us to meet in Confer today to talk about the handling of confidential information as we go forward. And so, to that end, here we are to talk about that and see what kinds of things we can come to an agreement on as far as how we handle it. In thinking about how to approach it, I had a few questions in mind for things that maybe we can talk about and think about, see if you're willing to consider, so we can kind of structure how we want to handle it, whether we proceed in court or before an arbitrator. The same kind of issues may come up, and it's fairly common in lawsuits, in my experience, actually thus far. Both sides have confidential information usually, and so we talk about ways to make sure that doesn't get out to the public sphere and we protect it.
Okay, and the scope of what the protective order is, what does Insight consider as confidential?
Okay, that's a great question. That's actually on my list. Typically how we approach it, it's very document specific or piece of information specific. Now it includes, at least as far as the confidentiality and a non-solicitation agreement, it would include proprietary business information and trade secret information, things that come up in the course of employment that, if in the hands of a competitor, would give that competitor an advantage, a competitive advantage. And so confidential and proprietary information is very broad, and what we tend to do is, if the party has a good faith basis that something is protected as confidential, then you designate it confidential, and then if the other party disputes that characterization, then we agree on some mechanisms to resolve that dispute.
Okay, and then according to the laws and rules that what constitutes as what's proprietary or a trade secret, I don't know what that is according to what Insight standards are, because I have not exposed any of that according to my knowledge of what those two meanings are as far as proprietary and trade secrets.
Okay, and what would happen is, as we set up a protective order, we would address those issues really specifically as they would come up, because you would analyze it sort of in a, if this piece of paper in front of you, if it had a calculation on it, we would say, is that protected or not? We would do it in a very specific sort of way, and how we set it up in a protective is. So are you willing to agree that if one party has a good faith basis that something is protected, that we'll consider it confidential information, and those would include things like the confidential proprietary business information. It would include personal identifying information as well. In the course of litigation, sometimes personnel files become important. You wouldn't want someone's bank account number submitted as part of their direct deposit to be disclosed. So it would cover those types of things to protect both sides. Sure. So the first step is, are we able to agree that if there's a good faith basis on either one of our sides that something is likely protected, can we designate it confidential?
That would be hard to agree to, because as of to date, I don't understand what Insight is designating as confidential and or proprietary or a trade secret, because they have not demonstrated that. They made a lot of broad generalizations in the exhibits that they showed. They presented excerpts from different contracts that they had with different partners and their customers, nothing specific to any of the particular information that was in my exhibits. So it's just a lot of broad information, and really, according to what constitutes as a trade secret, none of which they have not demonstrated any of the information to be trade secrets, any of the information to be specifically what would constitute as giving them a disadvantage competitively. They haven't done any of that. I haven't seen any demonstrations of that, so I would definitely need to know what they are designating as a trade secret. What do they mean as a trade secret? Because it has not been demonstrated to me, or I totally don't understand it.
Okay, so, sorry.
And possibly, can they give me some type of written documentation? What is confidential? Because none of the emails or anything, nothing has been designated as confidential. So that stuff was just information, and a lot of the writings are my own, in which I am the author of. So that's my information. So,
well, I understand your information. I think two things. I think the confidentiality and non-solicitation agreement is a great starting point to try to so we've come to agreement on what is considered confidential and proprietary information, which is different than a trade secret.
Right.
So there's
totally.
so there's a couple different categories, and that's also different than the personal identifying information and all of that stuff. So we've got a couple different categories here, and I think that as a first step, what's identified in the confidentiality and non-solicitation agreement, information that could be covered by that agreement, would be our very first step. If it falls into those categories listed there, we would consider that confidential, and we have a good faith basis to believe that it is. I think the second piece of it is, you're right, it's hard to know exactly what everything is, because not everything in every document may be confidential. In those instances, we sometimes use redaction to remove only a portion that's considered confidential.
That is one of the things that I would consider, is redacting some of the personal information, as far as like my coworkers' names. So redaction of information, a coworker's name, that's understandable. Even a customer's particular name, understandable. And for the entire scope of the complaint, I believe I have redacted or kept secret that customer's name. But in some of the exhibits, it do expose customer's name, so I don't have a problem with going back to those exhibits and crossing those names out.
Okay, that's a great start. And I think with some of, I believe, and correct me if I'm wrong, that John may have sent a list of some of the exhibit numbers that would contain some information that Insight would consider to be protected. So if we start with the basis of what's covered under the confidentiality non-solicitation agreement, how that's defined, and then look at some of those specific examples of how Insight is interpreting that to apply to certain customer names, is a big one, because some of the agreements with customers do require us to not disclose there's even a relationship there. So those would be good starting points, and some of the internal processes and procedures of how Insight does business, which, if in the hands of a competitor, they could take that model and use it to defeat Insight at its own game, so to speak. Those would be things that we would say there's a good faith basis. We believe it's confidential. We would, faith basis, designated confidential. And then that doesn't mean you can't use it, because part of what we'll talk about as we go down the list is, how do you use confidential information? Because there's nothing we're talking about here that prevents you from using the information to pursue your claims. It's just how we use it is what we got to figure out, so that if we have a legitimate concern, or you have a legitimate concern about something being in the public sphere, we seal it or we redact it, so that you and I, or both sides, will both know what it is.
Sure.
But Joe Q, public on the street, is not going to know what it is.
Sure.
Does that make sense?
That does make sense to me. But what we also need to make sure that, just because Insight is industry is, as a reseller, and a lot of the practices at Insight, the day-to-day operations and employment, or doing that particular job that I had as an account executive, I mean, that information and those practices are common throughout the industry. So you can't say that that is a trade secret, or just it's going to give the competition an advantage over Insight if the information is exposed, because that's common information and it's common practices throughout the industry. So I would need to take a look at and I don't use that email address that John sent information to. So that is
good to know.
Yeah, I need to go and figure out which exhibits he's talking about, and so maybe I need to go back and take a look at it, because I have not.
Okay. And you raise a great point, because what we do typically include in sort of a protective order that applies to the case going forward is a way to resolve a dispute if for instance, we say it's confidential and you don't agree. In that very situation which you described, we would have in our agreed upon